Hi, everyone. I'm Jen Leonard, Executive Director of the Future of the Profession Initiative, and I'm pleased to welcome you to Reimagining the Future of Legal Regulatory Reform, the fourth webinar in the Future of the Profession Initiative's spring webinar series on reimagining the future of the legal profession. This spring, we're exploring a variety of topics that highlight change in the modern legal profession. These sessions have focused on the future of legal work environments, artificial intelligence and machine learning in legal services, and racial equity in the profession. Next week, our series will conclude with a conversation led by our dean about the future of lawyer formation. Today, though, we focus on the future of legal regulatory reform. Our moderator for today has planned an educational and dynamic conversation with our guests, and I'll introduce him in a moment. During this spring series, we've added the opportunity for those of you who, like me, missed the chance to connect with program attendees and further explore the topics the panelists address through a post-webinar discussion from 4:30 to 5:30 Eastern Standard Time. We hope you'll join us for this discussion, and we'll share more information about it at the end of our program. Before I introduce our moderator for today's event, a few housekeeping items. We encourage you to share your questions with our panelists. You can use the Q&A feature found on the ribbon at the bottom of the window. The Q&A portion of our program will be facilitated by 3L student Bridget Lavender beginning at 4 p.m. Eastern Standard Time. Since we'll only have 15 minutes for Q&A, Bridget will select the most popular audience questions, so please use the controls to upvote any questions you'd like our guest experts to answer. Please keep your questions topical and appropriate. Anyone posting inappropriate content will be removed from the webinar. We'll be announcing CLE codes twice per hour for these sessions for those seeking CLE. You should write down these codes and enter them on your digital evaluation form once the event is over. The form is mandatory to receive CLE credit, and a link to the evaluation is in the chat. Attendees must attend the post-webinar breakout discussion from 4:30 to 5:30 Eastern Standard Time to receive 2 credits of CLE. And now, here is the first CLE passcode. Are you ready? The passcode is STUDY, STUDY, study. And now, without further ado, I'll invite our moderator to join the discussion. We are so fortunate today for our conversation to be led by our esteemed alumnus, Jim Sandman, distinguished lecturer and senior consultant to the Future of the Profession Initiative. Jim has had a long and varied career in private practice with a global law firm, in government service, and as a public interest lawyer. Jim is President Emeritus of the Legal Services Corporation, the largest funder of civil legal aid in the United States. LSC supports 132 independent legal aid programs with more than 850 offices serving every state and territory, and Jim was its president from 2011 to February of 2020. He practiced law for 30 years with the international law firm of Arnold and Porter and served as the firm's managing partner for a decade. Immediately prior to joining the Legal Services Corporation, he served as general counsel of the District of Columbia Public Schools. He is past president of the 110,000-member District of Columbia Bar. Jim has received many awards for his work, including Penn Law School's Alumni Award of Merit and its Howard Lesnick Pro Bono Award. He's also received the DC Bar's highest honor, the Justice William J. Brennan Jr. Award, as well as the Wiley A. Branton Award from the Washington Lawyers Committee for Civil Legal Rights and Urban Affairs, and the ABA's Presidential Citation. We're thrilled that Jim recently joined us here at the law school to teach, including in courses on professional responsibility and his new seminar this spring on leadership in the law. Jim also mentors the next generation of lawyer leaders at Penn Law, leads projects designed to improve legal systems, simplify court processes, and expand access to justice, and to bring conversations like the one you're about to hear to the broader profession. Jim has been a vocal advocate for legal regulatory reform that aims to better connect individuals across the income spectrum with legal help, and he's assembled an excellent panel to discuss those efforts today. You can learn more about Jim's and all of our panelists' backgrounds, watch videos of our past webinars, and register for our final session next week by visiting our event splash page at futureofthelegalprofession.org. And with that, I will turn the reins over to Jim to introduce our excellent guest panel and to lead our conversation today. Thank you, Jim.
Thank you very much for your kind introduction. I want to welcome everyone to our webinar this afternoon on reimagining the future of legal regulatory reform. The market for legal services in the United States shows many signs of dysfunction. as reflected by a number of different measures. The Legal Services Corporation's 2017 study of the justice gap, that is the difference between the civil legal needs of low-income people and the resources available to meet those needs, showed that 86% of the civil legal needs of low-income people either get no help at all or inadequate help. The statistics that are most astonishing and troubling to me relate to the high percentages of unrepresented litigants in our courts today. The National Center for State Courts estimates that in 76% of civil cases in state courts, at least one of the parties does not have a lawyer. And that figure, 76%, doesn't include family law cases. If it did, the percentage would be even higher. I tell my students that what that means is that every case they read in law school is unrepresentative of what actually happens in the majority of cases in the United States today. I'm actually making an educated guess in saying that. I think it's highly likely that every case in a law student's casebooks was litigated with lawyers on both sides. Otherwise, it's unlikely that the judge would have been able to write an opinion of the quality necessary to find its way into a casebook. But our notion of a case where a lawyer presents evidence and argues the law on behalf of a client on both sides is a fiction in the vast majority of cases in our country today. The failure of the market to meet legal needs affects not just low-income people. It affects the middle class. It affects small businesses. It even affects larger businesses, which not infrequently conclude that the costs of litigation are simply too high to justify suing over disputes involving less than, say, $1 million. These problems have focused attention on the role of the regulation of legal services in limiting access to legal assistance, and on the potential for regulatory reform to expand access. I'd like to introduce our three panelists, all experts in the regulatory reform movement. Dave Byers is the Arizona Supreme Court's administrative director of the courts. In that capacity, he is responsible for overseeing the operations of the entire Arizona state court system. He's been in that role for 29 years and has served in the administration of the Arizona courts going back to 1978. He's a past president of the National Conference of State Court Administrators and previously served on the board of directors of the National Center for State Courts. Justice Dino Himonas was appointed to the Utah Supreme Court in 2015. For a decade prior to that, he served as a district court judge in Utah, in a district where more than 80% of the litigants are unrepresented. He was a litigator before that. He has been a leader on the Utah Supreme Court in that state's regulatory reform movement, which you'll be hearing in detail about in a few moments. And Rebecca Sandifer is professor in the School of Social and Family Dynamics at Arizona State University and was named a MacArthur Fellow in 2018 for her work on inequality and access to justice. Her groundbreaking scholarship has investigated access to civil justice from every angle, from how legal services are delivered and consumed, to how civil legal aid is organized around the country, to the role of pro bono, to the relative efficacy of lawyers, non-lawyers, and digital tools as advisors and representatives. Becky is also a faculty fellow at the American Bar Foundation. Welcome, distinguished panelists. I'd like to start with Becky. And Becky, I'd like to ask you to tell us about your research on the current market for legal services in the United States and on unmet civil legal needs.
Well, thank you, Jim, and thanks so much for the opportunity to be with you here today and talk about these really crucial issues. if you're a research nerd, one of the great things that's happened in the past 10 years or so is that we've learned a lot more about the US legal services market than we knew before. And we've learned about both what's happening in trials and hearings, but we've also learned about ordinary people's experiences from surveys that ask them about the kinds of problems that they have and who they go for help with them and how they think about them. And what this research taken together tells us is that the justice gap is huge. And as Jim said, it's not just about poor people, it affects many groups in the population. And as Jim said, it has multiple parts. And so the part that as a law student or a lawyer, you're probably most familiar with, it's unrepresented litigants, the 75% to, in some instances, 99% of cases that have at least one party with no attorney. And so people are left alone to navigate processes that are arcane, that seem complicated to them without any assistance. And just to give a sense of what that means in terms of magnitude. So these are all pre-COVID figures. And if you think about that, all of these numbers will have increased. But if you're looking at something just evictions, that's 3.6 million evictions a year. Or wage garnishment, which is a legal action that happens to you, that's 4 million people a year. There are about 1.5 million guardianship actions for adults every year, where other adults come in and take over some or all of the affairs of a grown person. And so these are issues that have a lot at stake and people have no help. It's about the care of people who are dependent. It's about having any place to live at all. It's about making a living and so on. But there's actually a part of the justice gap that's much bigger that exists outside the court system. So our best guess, based on the data that we have, is that Americans every year will experience 150 million to 250 million new civil justice problems. So this is things like wage theft, foreclosure, trouble attaching to a pension or to some other kind of benefit. And again, to put some pre-COVID numbers on this, that's 7 million people who are behind on their student loan payments and therefore at risk of default. It's 2.5 million grandparents raising grandchildren, and so having to get powers of attorney or other kinds of documents so that they can enroll their kid in school or get them vaccinated or whatever. It's about 8.5 million people living in rental housing where the conditions are so bad that they violate municipal housing codes. And so those are folks who may need some legal action to compel their landlord to get rid of the rats or turn on the heat or so on. And as Jim said, whether you're looking at people in court or people out broadly in their communities, 75 to 85% of these people will get no assistance at all with those issues. And that's true whether you're looking at poor people, middle-class people, small businesses, or as Jim points out, sort of somewhat larger businesses. So that's the real justice gap. It's these tens of millions of people facing problems that can change their lives in very adverse ways with no assistance at all. And so one way that we often think about this, particularly when we're thinking about low-income populations, is that this is a vast ocean of unmet legal need, right? So there are lots and lots of people out there facing these issues who need help. But there's another way of thinking about it, which is that a large portion of that is happening to people who could afford to pay something for legal services. And so that's a vast, untapped, latent demand, potentially, for legal services. So there's a problem to be solved here, but there's also an opportunity, I think, that lawyers and others could take advantage of.
Becky, what does your research show about the reasons there are so many unmet legal needs?
So when I started working on this question about 20 years ago, everybody, including me, already knew the answer to that question. And we thought it was because legal services were really expensive. And they certainly can be. I mean, many legal services can be very expensive, but people don't even buy inexpensive legal services. And that's because people, for the most part, are not at the point of finding out how much a legal service would cost. They're not looking for legal services. They're not wishing for legal services. They're not thinking about lawyers at all. And one of the ways to see this is to ask them how they think about their own justice problems. So a few years ago, I did a survey where you ask, it's a sort of a standard method now, where you ask people not tell me about your legal problems, but are you having these specific circumstances in your life? So are you 3 or more months behind on your rent? So that would make you at risk of eviction, but you may or may not know that. Or does your employer owe you overtime, but he's not paying it? Well, that's wage theft, but you may not know that. Are you living in an apartment that has no heat or hot water, right? So you ask about these specific situations that are all justiciable, but you ask about them in a way that an ordinary person doesn't need to know anything about the law to tell you that this is happening in their life. So if people report these things to you, they're behind on their rent, their wages aren't being paid, and then you can say, okay, you've told me you had this situation. What kind of a problem is it? Is it a legal problem? Is it a moral problem? Is it bad luck? Is it part of God's will for you? Is it a bureaucratic problem, a personal problem? And that produces some really striking findings. For over half of problems, so for 56% of the justiciable situations in people's lives, Americans will say that it's either bad luck or God's will for me. So it's either something that just happens to me or it's supposed to happen to me. And so when you start to think about how that would shape the way you would respond to that problem, are you going to call a lawyer or file a lawsuit about what you believe is your destiny or what you just think is sort of part of everybody's lot in life? There's another bunch of problems that people think of in ways that suggest maybe somebody, they would welcome the involvement of somebody, but that somebody is somebody inside a community that is sort of includes them and maybe close to others. So they'll describe problems as private problems or community problems or family problems. Somebody could help me with this, but it's part of us. And so if we were there in a room together, I would ask you to guess the percentage of legal problems that people have that they describe as legal. But since we're not there and I can't have you guess, I'll just tell you it's 9%. So that means for over 90% of the civil justice problems that people experience, they do not recognize those problems as having legal aspects. And if I don't think my problem is a legal problem, why would I go to legal help to try to solve it?
You're muted, Jim.
In light of what you just said, what do you think the relationship is between the regulatory system governing the delivery of legal services and unmet civil legal needs?
So I would say there are a number of mismatches from the perspective of the public. So there's a huge mismatch between what people want, what they understand themselves as needing, and in the US, we don't offer a lot of options. So you have two choices. You have lawyers, usually, or nothing. And lawyers are not very discoverable for people who face actual concrete problems. Lawyers are historically pretty bad at explaining that they offer something that's relevant to someone who understands themselves as not having a legal problem. So you hang out a sign that says legal help here, and most people don't understand that that's help that they could actually use. Another important mismatch is that because of the way it's lawyers or nothing, full service representation is actually often disproportionate to the kinds of help that people need. So if you look at studies where we ask people what their situation is and what kind of help they want, what they really often want is legal advice. They want to know what form to use, how to answer a question on the form, what their options are, and so on. And I'll give you a couple of examples. So I was observing in a court self-help center. So this is a place where you can go if you don't have an attorney and they can help you understand what the steps are going to be and give you forms and so on. And so as I was observing, a woman came in and she said that she was having surgery and she wanted to get the forms to make her friend the guardian of her child. Now, the person in the self-help center is not supposed to give her legal advice, but luckily for this woman, that person did give her legal advice. She said, you know, if you make your friend the guardian of your child, then he has custody of your child. And he can prevent you, for example, from ever seeing her again. So I think you don't want that document. You want this other document, the limited power of attorney for this short period of time, right? And so that was legal advice that absolutely helped that woman get the solution that she actually needed for the problem that she actually had. I'll give you another example. Debt collectors of different types very often will call up the children of deceased debtors and claim that those descendants have to pay back their parents' debts. That's usually not the case. So there are many, many kinds of debts that die with the debtor. So what those folks need is someone to explain to them, actually, you don't have to pay this money. You're not on the hook for it. And also they can't keep calling you and they can't call you at work and so on. And so those are two examples of how very discrete legal services could make a big difference in people's lives around significant issues like care of your child or your finances. The other thing we see is that in the US context, people are actually quite happy to use non-lawyer service providers when they're available. So for 60 years or so, non-lawyers have been able to represent people in a range of administrative tribunals, Social Security, disability hearings, unemployment, state tax courts. They can be representatives in immigration courts. And if you look at the data we have across those settings, among people who are represented, these non-lawyers are providing 20 to 30% of all the representation. So people are certainly willing to use them when they're available.
The example you gave of the person getting help from the court self-help center, she got that help, notwithstanding maybe in violation of restrictions on the unauthorized practice of law. What do you say to that? That helper is at risk of losing her job or worse.
Yes.
As a result of our regulatory system.
Yeah.
Tell us how other countries regulate legal services and what you think we can learn from them.
So there are a range of other countries, and probably the most notable one for this conversation are the different parts of the UK, because we're both common law systems, we're their younger brother, however you want to think about it. So those jurisdictions have no restrictions on who may give legal advice. So non-lawyers can give legal advice and they can get paid for it. And that's an important part of the way those countries see themselves as providing access to justice. So a few years ago, a scholar named Richard Moorhead and some of his colleagues did a study comparing the quality of the legal services offered by non-lawyers and lawyers in England and Wales. And this was an audit study where experts come in, they take a random sample of the work product in both of those different kinds of providing organizations, and they review them for the quality of the work. And they did this across a range of civil areas, so debt, family, immigration, finance, and so on. And the findings were really, really striking. So both, it won't surprise you if you've ever done work that we all make mistakes, right? So both the lawyers and the non-lawyers made mistakes. And for both of them, the way that the assessment was sort of like pass or fail, below threshold competence was failing. And both groups failed at 25%. So the lawyers made significant errors 25% of the time, and the non-lawyers made significant errors 25% of the time. But it also means that 3/4 of the time, they're both doing a solid job. So clearly non-lawyers can do good work. But that study actually offers an even more striking finding, which was, so you can do good work that's solid, or you can do A work. You can do really excellent work. And some of the lawyers and some of the non-lawyers did really excellent work, but the non-lawyers were 6 times more likely to do excellent work, like really super high quality work, than the lawyers were. So this tells us that people will use these providers when they exist, and that these providers can be quite effective and competent. And we can also point out they're also often cheaper, but maybe that's a part of the conversation that comes later.
Well, the rationale for restrictions on the unauthorized practice of law in the United States is to protect consumers, to protect them from incompetence, from unethical actors. But you're saying in the UK, there are no such restrictions.
That's right.
How do they protect people, or do they?
Well, I mean, people have access to all kinds of consumer protection law when they buy anything. So you would have access to that. The UK has a more hands-on approach to regulation than we do in terms of consumer protection. So there's a legal services ombudsman, and I could go to that ombudsman, part of the central government, and say, Dino Jimenez said he was going to write my will, and instead he wrote some stuff on the back of an envelope and charged me $500. And then that ombudsman would investigate that complaint and resolve it in a way that's binding. The other thing about the UK is that its advice sector is very well established. So every postcode, they call them instead of zip codes, has a physical Citizens Advice Bureau office where trained community volunteers know how to help you interpret that scary letter that you got, or know how to write a demand letter to your landlord or something like that. And that's been around for 60 years. And it's been around because, this is kind of a funny story, after World War II, many people had entered into precipitous marriages. And the UK has a fairly generous legal aid system, but they realized we can't pay for lawyers for all of these fairly straightforward, uncontested, whoa, that was a mistake, divorces. And so they developed this set of other services, relying on the fact that there were no restrictions on legal advice, to help people do this very routine stuff. And now that's totally trusted and it's everywhere, and it's a part of their culture, I guess.
You do very interesting research, Becky. So tell us, before we move on to Justice Simonis and to Dave, tell us, what would you recommend in terms of regulatory reform in the United States to provide more legal assistance to people who would benefit from it?
So if you look at the things that are under consideration right now, the way I think about them is part of them are about changing the rules about who can make money from the practice of law. So can people who aren't lawyers own law firms? Can lawyers share their fees with other kinds of people? And then part of them are about allowing people and things that currently can't practice law to practice law. And I think we have to do both of those things. So think about what rich people who run large organizations already have access to. They have access to providers of solutions that wrap those solutions around their problem in an integrated way. Even though UPL still says they can't share fees between accountants and consulting firms, there are already great kind of wraparound services for the legal needs of very well-off organizations. Imagine if you could do that for an ordinary person, right? So you could have services that meet the actual parts of the problems people have. These changes would make that possible. Another thing that you see in the research, as I tried to show, people don't think of their problems as legal, so they're not going to where lawyers are. Well, what if you put lawyers where they were, right? So sometimes in the US, we call this Walmart law. Well, they have it in the UK. You could go to the grocery store and there are lawyers there, or these non-lawyer advisors, and that's where you are looking for your eyeglasses and fish food and legal advice about problems of life that are quite pervasive. So I think both of those changes together give the opportunity. I would add one third thing. They give the opportunity for legal services providers to be more diverse. So right now, if you want to be a lawyer, it's not a 3-year degree, it's a 7 or 8 year degree. And not everybody has access to the opportunity to not earn money for all of that time while pursuing that education. And so if you open up more routes for people to become providers of legal services, that can diversify the entry points in yet another way into justice, which is what we're trying to do. We're trying to open those doors so that there are many places that people can come in.
Thank you. I'd like to Justice Simonis and to Dave to talk about what you've been doing in Utah and Arizona, 2 states that are leading the regulatory reform movement in the United States. Can you tell us what the motivation for reform has been in your states? How did you get started? Have you coordinated in what you've done? Justice Simonis, do you want to start?
Thank you. And let me echo Becky and say thank you for the invitation and the opportunity to speak to you all. This is something that I think you'll pick up pretty quickly. I feel passionately about. The motivation in Utah is singular, and it's to narrow the access to justice gap. It's not about anything else. It started back in 2015 with our work in allowing licensed paralegals to begin practicing, moved on to providing online dispute resolution forums within the court system. And then most recently, and what we're really here to talk about is the creation of a legal regulatory sandbox, the world's first legal regulatory sandbox, to allow some experimentation with, having non-traditional providers that are providing non-traditional services and non-traditional providers providing traditional or non-traditional services. That's it in a nutshell.
Can you describe what a regulatory sandbox is and how it works in Utah?
Sure. So, a regulatory sandbox is just a fancy way of talking about providing a space where somebody can come and propose having certain restrictions lifted to allow them to try to innovate in that particular space. In Utah, in the legal market, it means that lawyers and others can come in and they can have and ask that any of the rules of professional responsibility be lifted. Non-lawyers can come in and ask that the UPL restrictions be lifted, and we're seeing both. And they go really to the first 2 prongs of changing our legal ecosystem that Professor Sandifer has outlined. And we're simultaneously working on expanding how you can become authorized to practice at the same time. That kind of that third area, which is a different regulatory metaphor, but recognizing that we also need to improve that route as well.
So if I understand it, the regulatory sandbox applies not just to exceptions to Model Rule 5.4, that is limitations on fee sharing with non-lawyers and non-lawyer ownership of legal services providers. It applies more broadly to other aspects of legal regulation. You can make a proposal to do things differently, to do things that without this exception would be prohibited by the current rules, and you get to test it in a protected environment.
That's right. And we go in. So let me give you a couple of examples. We have a women's shelter that has applied and been approved to have people that are domestic violence advocates, non-lawyers, now be able to provide legal advice and help those individuals who are, perhaps suffering domestic violence or other forms of abuse, present their case. So they may not be making the presentation, but they can advise them on how to fill out the forms, what evidence is necessary, how to go about the whole process of getting your protective order or your stalking injunction. So it has nothing to do with the economics. On the other hand, we have lots of applicants that are looking to have 5.4 lifted, which would allow for kind of a whole new business venture. And that I'm happy to talk today about why that's really important to solving the problem as well.
Let's turn to Dave. Dave, can you tell us what your motivation was in Arizona in going down this road?
Sure, Jim. And I guess maybe ours might have been a little broader than Justice Hamona's. First of all, we had done many things prior to the steps we've recently taken. We invented self-help centers and courts here in Arizona, and we had a tax credit for pro bono, or you can donate money to legal aid and get 100% of it back through a tax credit. We could go on with things we did, but they just didn't do enough. And so our task force was charged with not only access to justice, and by that I don't just mean for the poor. Like you said in your opening comments, people making $100,000 a year can't afford a lawyer in a civil matter or in a divorce matter typically. And so it was really access to most citizens in Arizona. Secondly, we wanted to spark new innovation in the delivery of legal services, even within law firms. And third, we wanted to bring additional capital to law firms. Law firms traditionally aren't capital rich, and if we're going to infuse new technology and allow lawyers to do things in more innovative ways, there had to be a way to bring additional capital, we think, into law firms. So for those three reasons, we made the recommendations we did, and then our court adopted the rules that followed.
As I understand it, Arizona, unlike Utah, doesn't have a regulatory sandbox. You just repealed, as I understand it, your equivalent of Model Rule 5.4.
That's right. We repealed it, and we debated that. Arizona also doesn't have a UPL law, so there is no criminal statute for the unauthorized practice of law. It hasn't been for decades. We decided in Arizona, we have already been regulating various kinds of firms that are associated with courts. So, for example, we have court-appointed fiduciaries, and we license the fiduciary individuals themselves, but we also regulate and license the firm. And we have revoked the licenses of both. We do the same thing for document preparers, for court reporters, and other groups. So we had experience with regulating firms, and we recognize that if we were going to do away with 5.4, you have to have a way to control the firm or eventually disallow them from practicing because they don't have a law license. That's the way we control lawyers, through the individual law license. In Arizona, we don't regulate the law firms, but in this case, we had to regulate the firm. So we had experience doing that. We decided to go that route. Also, our rules are permanent rule changes. They weren't a temporary change. And this was meant to help attract the capital and the investment in innovation. We were concerned that if we if our court had adopted and said, we'll do this for 3 years or 5 years or on a temporary basis, it might discourage companies from coming into Arizona. So we just took a slightly different route than Utah has.
So it sounds like you're trying to stimulate a more entrepreneurial approach to the delivery of legal services,
Yes.
to bring more sources of capital in and different ways of thinking.
Yes, and in fact, next week our ABS board, it's like the character and fitness board for ABSs. They're going to probably approve the first applications, and I noticed the first one is just a firm of two people. One is a financial planner, certified financial planner. The other is a lawyer. They've been referring cases back and forth for decades, probably, but they're now forming one unified firm. And it goes to what Becky's saying. There are a lot of people who want to come in and do your financial planning and coordinate that with the lawyer for estate planning, for wills and trusts, and have that in one shop rather than trying to coordinate, professionals separately. So that's an example that I'm sure they're not appealing to low-income folks in that firm, but it's going to be a different way of them providing services to their clients.
Some have described the changes that you've adopted in Utah and Arizona as radical. And there's been a lot of surprise that you've implemented them. I'm wondering how you solicited feedback on these changes when they were merely proposals before you implemented them, to what extent the public had an opportunity to participate in the comment process. How did you go about getting this approved?
Well, I guess I can go first. So our task force met a number of times, chaired by our Vice Chief Justice. All
We're not hearing you, Dave.
back.
You're back.
Sorry, occasionally this cuts out. Our task force met numerous times and had the public and had stakeholders at every meeting. People would come and testify to the task force. But once the recommendations were made, we posted what we call the rules that would implement this in a forum that allows written comments. Now, we know that most of those comments were expected to come from lawyers. The general public usually doesn't sit around looking at our websites making comments. So we aggressively went out because we said, well, in addition to hearing from lawyers, that's important, we need to hear from the public. And we went out and we commissioned a statewide poll of Arizona citizens through a firm to get the opinion of general citizens. And we also commissioned a group to go out and do, I think it was 6 or 7 focus groups with members of the public as well as people who work with the public, low-income housing folks, community service agencies, legal aid, and so forth. So we knew we'd get responses from lawyers. We anticipated, frankly, that most of those would be negative. And we wanted to also give our Supreme Court we wanted them to hear from other people besides the lawyers so they could evaluate both. So we had a pretty aggressive plan to bring in public input into our process.
And what did you hear from the public?
Well, the public overwhelmingly supports these items. It was about 80% of the public. The same thing happened years ago, 50 years ago. Our Supreme Court ruled that doing a real estate transaction, conveying real estate, was the practice of law. And the real estate agents didn't like that. In Arizona, like Western states, we have the initiative process. They went out and got signatures to put an issue on the ballot to change our Constitution to specifically allow real estate agents to practice real estate law. The lawyers were opposed to that. The state bar opposed it based on it would harm the public and they weren't trained well enough to do real estate transactions. Well, the public passed it by 80%. And so for the last 50 years, we've had non-lawyers practicing real estate law and everything's fine. So we know it can be done. And so we had exactly sort of the same breakdown. The exact same arguments against the items that our court adopted were the same ones we saw 50 years ago. And the breakdown between the lawyers and the public was really the same.
Dino, what about in Utah? How did you go about getting comments on what you were considering doing, and what did the comments show?
So we uh, started off down the traditional road of doing a lot of dog and pony shows with the bar, speaking wherever and whenever we could about the issue, publishing the proposed rules and soliciting feedback. But to be really candid about it, we piggybacked off of Arizona here. This goes back to a question you'd asked earlier about whether we're coordinating, and yes, we've been speaking about this, aware of the survey that was being done in Arizona, and didn't feel the need to kind of just replicate the development of the wheel here. The populations are similar enough that survey would be really informative of what we're doing. Had people from Arizona that have been participating in Utah in some of our groups, and I had the privilege of being invited by Dave to participate in their group. So working closely together, and frankly, in this case, Arizona's done an outstanding job of soliciting public input, and we unabashedly piggybacked on that.
Jim, one other thing I'll mention, we may be a little different. Decades ago, our Supreme Court made a decision that we were going to put public members, non-lawyers, non-judges, non-court staff, on all of our policy and advisory committees, including our state bar board of governors. And so we have, I think it's 4 or 5 public members that serve on our board of governors. And when the issues came up to the board of governors for their vote, either support or oppose, they take 2 votes in a month apart. And the first vote was very split, but I think there was one more no vote than yes. And the public members asked for the staff to prepare comments both ways. At the second meeting, after the public members supported and spoke very eloquently for the need, the vote completely turned around, and our board of governors actually endorsed the recommendations that the committee had made. And I'll also tell you one other surprising thing. While we had, there might have been 100 comments. We have 25,000 active attorneys, so there were about 100 comments, I think. After the vote and after the court adopted the rules, I have not heard one negative thing. There's been no blowback from the attorneys. In fact, I've had dozens of attorneys calling and writing and saying, gosh, I wish we had done this years ago. We needed to do it. So it was an interesting dynamic of some negative reaction initially, but not since the vote, not since the court adopted these proposals.
Well, Dino, in Utah, you had an experience that looked to me like a man bites dog story. You actually had the bar leading on the proposed reforms, and had the president of the Utah bar partnering with you to propose these changes. How did that happen?
Right. So Dave and myself and the person you're mentioning, John Lund, who was president of the bar at the time, and a few others had the privilege of being in Washington, listening to a presentation addressing these issues, and the light bulb went on, and light bulb went on for John. John, if you get to know him, is a force of nature. I mean, I think he recognized the moral imperative here, and led the bar to solicit the court to form the work group to start this process rolling. So yeah, I mean, talk about lucky.
Well, I've looked at the data about how the public reacts to these proposed regulatory reforms compared to how lawyers react. And I've looked at data from Utah and Arizona and California, and they all tell the same story. The public, by a supermajority, approves regulatory reform by about the same supermajority percentage that lawyers oppose regulatory reform. Lawyers usually phrase their opposition in terms of consumer protection issues. This is about protecting the public, but you ask the public directly and they say, bring it on, that this is something we want. Becky, how do you, from your perspective, explain this difference in perception that lawyers who consider themselves charged with an obligation to protect the public from incompetent and unethical actors look at these reforms and see a parade of horribles, whereas the public says, we love that.
Well, I mean, I think the public comments that you get from the bar certainly tend to skew towards the negative, but my observation would be about lawyers is they're not unified in their opposition to this. So there are some groups of lawyers who see this as an opportunity to make it into new market shares, to go back to some points that were made earlier, to capitalize their firms and be able to do things that they weren't able to do before, to enter into partnerships that allow them to better serve their clients. So there are many lawyers who see that. There are other lawyers who see, I think there's two classes of things. So they have settled relationships through which they currently get their client flow, and this is going to disrupt those settled relationships, which it is. That's what it's supposed to do. Or they're worried about robot lawyer, so if some very, not robo lawyer, robot lawyer. So some very sophisticated computer program that can do part of what it is that they do. And that's actually already happened, right? So if you're in big firm litigation, there are already computer programs that do what armies of associates used to do with files and pencils and stuff like that. I mean, this is just what happens in this moment in history. People are not thinking, I'm not saying lawyers are not people, although we could make that a topic of conversation. Ordinary people are not thinking about the unauthorized practice of law or the rules about the ownership of law firms as having anything to do with their problems, which are what they want solved. So when someone comes to them and says, right now you have one really expensive choice for how to work on your problem, but if we change these rules, you could have 10 choices at different price points. Some of them might be closer to you, some socially, some of them might be closer to you physically. Would you like that? People say, yeah, that sounds great. And if you go to jurisdictions where Ontario is really weird and interesting, so they had unregulated paralegals running around offering paralegal services independently, and then they decided to regulate them. So as part of that, they did some surveys of the public about, should we regulate them? And people said, sure, fine, if you want to. They didn't feel too strongly about it. But then they asked them, people who were clients of these paralegals, what they thought about it. And people loved the fact that they were accessible, that they were responsive, that they explained what was going to happen, that they answered your questions. So what people want is services organized around them. And I think they correctly see that these new models and new providers can offer those kinds of services.
Well, Dave, I saw the video that you did in Arizona to educate people about your licensed paraprofessional, licensed paralegal provision, where you made the analogy to the healthcare field, where you have not just doctors, but you've got registered nurses and licensed practical nurses and physicians assistants, which seemed to me to be a very relatable way to explain what you were trying to do. What reaction did you get to that?
Yeah, that was very easy for the public to understand. We were proposing what wound up being called legal paraprofessionals to a nurse practitioner. And they could understand that and were very supportive of that idea. And they understood that these LPs wouldn't be doing everything, but they'd have a limited role. When nurse practitioners were proposed about 50 years ago, doctors opposed them, just like lawyers opposed these changes. And yet, if you now went to a doctor, of course, they embrace nurse practitioners. So we see the same thing. We don't think that you have to have a JD degree to do every single legal service that the people want. But just like in the medical field, you don't go to a nurse practitioner if you want brain surgery or if you have cancer. Heck, you don't go to a family physician if you want treatment for cancer. You go to a specialist. And so we hope in Arizona we'll wind up with a variety of practitioners that will be able to practice in limited ways in different areas at different price points for people of Arizona.
I want to ask you, Justice Simonis, and you, Dave, about the role of your state Supreme Courts in this. We often talk about law as a self-regulating profession, lawyers regulating lawyers, but that's actually not accurate. The regulatory authority ultimately is vested with the highest courts of the states. From my perspective, one of the reasons that you've been successful in implementing the reforms that you have is because of very strong leadership from the Supreme Courts of your states. Justice Simonis, you personally, but also your entire court, his board, similarly with you, Dave, in Arizona. So can you say something about the role of the Supreme Courts to be active in using the regulatory process to try to improve the justice system for people?
Sure. So, look, the court some time ago, so started off saying, recognize the enormity of the access to justice gap. And just to give you an idea of what I'm talking about in Utah, and I'm relying on some work by Professor Sandifer, Professor James Tufel, and Dr. Tom Clark, for the portion of the population that's at 200% of the federal poverty guidelines or less, just under 1 million legal problems, 944,000. Middle income people, 409,000. Unserved legal needs for small businesses, 1.6 million. We're talking about a state with 3.5 million people in it, right? Once our court really understood the enormity of the gap and the crisis, the leadership came. I mean, that was second. But yeah, because we are ultimately responsible, it's critical that the court take on that role. And I'm, Arizona is the same place where I think Arizona is ultimately the Supreme Court is responsible for the governance. Now, in some other states, that won't be the case. The legislature may be, and I think perhaps that they need to be responsible for the push. But you need that kind of internal push and drive, I think, to overcome the inertia of moving, launching an entirely new regulatory model.
Yeah, and across the country, some Supreme Courts have kind of deferred all of that activity to their state bar. Others are more active, like my court. And my former Chief Justice, Scott Bales, was the one that initiated this task force. And it was his probably leadership and drive to get it started. Then it took on a life of its own. And one of the big differences I think you've got to explain to the court is they're there to regulate the practice of law, not to regulate lawyers. They do regulate lawyers, but it's a subset of the practice of law. And once they realize they're there to regulate the practice of law, then you start looking at alternatives or things in addition to the lawyers. Now, before we did these new regulations, we have Rule 31, which coincidentally had 31 different exceptions for non-lawyers to be able to practice in various forums. And so we already had a long history of authorizing, people to appear before tax courts or various things. And so this was kind of the next step. Also, I should probably mention in Arizona, 15 years ago, we established a legal document preparers program. And they actually can do quite a bit of work in a very broad area, but it's basically filling out forms, documents for citizens. We have 700 of them. And we've had them for 15 years, and that number has stayed pretty constant. They have to renew their license every 2 years, so they're out there. We get less complaints per capita on them than from lawyers, and almost none of the complaints against document preparers come from consumers. The consumers are very happy with their service. The complaints we usually get are from lawyers saying that the document preparers went too far, they did too much. So again, we have this experience that we know in certain areas non-lawyers can practice law effectively. And we got to get our courts to recognize that they're there to regulate the practice of law. It's not only regulating the attorneys.
Well, I want to ask you all what you're seeing so far. I know it's early days for the reforms that you've adopted recently, but what are you seeing in terms of applications, uptake on what you've enabled? And Becky, I would like you to answer too, but you have a role with the Utah Office of Legal Services Innovation in considering Sandbox proposals. And as a part of that, or separately from it, if you don't have enough experience yet to say what this might yield, what is your guess about the difference that the changes you've adopted will make in narrowing the justice gap, not only for low-income people, but for the middle class, for small businesses?
Becky,
Well,
sorry, you ought to take.
Go ahead, Justice.
I was just saying, Becky, you ought to take the Sandbox part, and I want to talk about perhaps some of the non-Sandbox initiatives that we've undertaken and growth there. Sorry, Dave.
So the Sandbox, I think it has 18 functioning organizations in it now. The CLE has just popped up in front of me. There we go. 18 functioning organizations in it now that so far have offered about 500 service contacts to people. So it's only been open since October. Again, I mean, it's only been functioning since October. So it will take a little while to ramp up. If you look at the kinds of organizations that have come in so far, most of them are lawyer-led, which I think is really interesting. So some of them are thinking about new ways to fund the production of legal services. Some of them are thinking about new ways to deliver. So using technology to do things in more sophisticated ways, using non-lawyer people in more sophisticated ways. There are a few, I mean, the thing to think about these kinds of rule reforms is that they're market-based. And so the natural flow of activity will be activity that makes its money on markets and can take advantage of market regulation changes. There are, I think, 2 or 3 nonprofit organizations that have moved into the Sandbox. And so as we think about how to create a really diverse, rich, healthy ecology, I think one of the things all jurisdictions will want to think about is how can we make it easier or more possible for people who don't make money off of what they do to take advantage of some of these basically market-based reforms.
Thank you. In terms of, sorry.
Go ahead, Justice, and finish up on Utah, and then I'll do Arizona.
So in terms of what we're really running 2 different models at the same time, right? We're running the Sandbox, in which the traditional or non-traditional providers can come in and offer traditional and non-traditional services. And we don't have a great front load on what those requirements are. If you pass, then we have big backload data requirements where we're actually trying to measure and see how they're impacting the public, if there's any harm to the public. And one note I need to make here that I neglected to mention earlier, and I think is really important. Another reason why this model is really different than the traditional model is we have non-lawyers regulating lawyers. About half of the Utah Innovation Office is comprised of outside experts, and bringing in that diversity, right, really lessening kind of the fox guarding the hen house issue, I think is really a positive one. Now, at the same time we're doing that, we've been running more of a traditional licensing model. So we started off with licensed paralegal practitioners. We've now expanded that. So there is a 1-year Master's of Law program that you can get at the University of Utah Law School. They'll be authorized to provide legal services as well. And discussions have started about bachelor's programs, which Arizona, really, again, piggybacking on Arizona in this regard, Arizona already has, that would allow them also to provide a different scope of legal services. And most recently, and I think for me personally, most exciting has been, and it's a preliminary stage, but conversations about licensing social workers writ large to offer, get training, certificated, and offer legal advice. So I really trying to, give us an opportunity not only to compare this model versus the Arizona models and others, and how it might impact the gap, but even within our own state, to try to understand what mechanisms, regulatory mechanisms, might best serve the public.
So in Arizona, I'll mention three components that we were working on. First, we authorized what's called domestic violence legal advocates, and they're like what Justice Damonis mentioned. These are individuals working with shelters and under the supervision of legal aid, non-lawyers. They've been authorized to go into court and provide legal assistance to victims of domestic violence. That program did get slowed down, I'd say, by 8 or 9 months because of the pandemic, but it's now geared up. People are going through their training, and shortly they'll be out there in operation. The second area is what we call the LPs, the legal paraprofessionals. Now, keep in mind, we already have 700 legal document preparers, and those people can practice in any area, in any subject area. But the legal paraprofessionals are actually authorized to go into court and represent people. That's the big difference. And they're limited to family court, what we call our limited jurisdiction courts. So that's civil matters below $10,000, criminal misdemeanor cases, evictions, debt cases, and so forth. Um, and they can also practice in administrative hearings, which is millions of hearings annually. So those people, those rules went into effect January 1st, and as part of their regimen, they have to be tested. It's a little bit different than a bar exam, but they have to be tested on subject matter information. And those tests were being developed. They're about done. So we'll start taking applications soon for those paraprofessionals. Now, we have all sorts of different levels of education and experience that qualifies you to apply to become an LP. And so people coming out of paralegal school, certified paralegal programs with some experience. We have programs, as Justice Hamonis mentioned. We have a BA program in law; they'll qualify. And even people who graduate from a bar, an ABA-approved law school, but who have not passed the bar can qualify. I mean, they've received a legal education, but they haven't passed the bar. They'll also be eligible to take those exams and go through character and fitness and become LPs. So, and the third component is the ABSs, the alternative business structures. So far, we've had 4 applications. That also, this started just January 1 for us. We have 4 applications pending. We've been in conversations with numerous companies and law firms. My guess is we'll get, a dozen, 15, 20 this year, something like that. And they're just starting the first meeting to approve their applications is next week. And so I expect to have several of them approved shortly.
Thank you. I'd now like to turn things over to our student moderator, Bridget Lavender. As Jen mentioned at the outset, Bridget is a third-year student at the University of Pennsylvania Law School. I met Bridget last summer when she was a student in my professional responsibility class, and I had as a guest speaker for our first class, Justice Hamonis. And Bridget was quite taken with Justice Hamonis's message, and to make a long story short, she's going to be serving as a law clerk to Justice Hamonis. Bridget has been reviewing the questions submitted in the Q&A. And Bridget, if you'd like to go ahead and begin reading out the questions for our panelists to answer.
Yeah, thank you so much. And everyone, please feel free to put more questions and we'll try to get to as many of them as we can in the few minutes that we have. But one of the first questions, it might even seem like kind of a silly, simple question to start with, but we can't help but noticing that you all are from the West, like you're from the West Coast, you're in Arizona and Utah. And so, what is it? Is it just that you're state Supreme Courts and that you guys have the leadership in those states, or is there, something else about the culture, about the legal profession in those states that makes your states more amenable? And how can we maybe move your models and all the amazing work you're doing to the East Coast as well?
Yeah, many times people blame the dry heat of Arizona, making us all a little crazy. But for some reason, the culture in the Arizona courts has always been to be creative and innovative. When I look at it from a governance point of view, one of the reasons it's easier here is we only have 15 counties. They're very large counties, but there's only 15 compared to you go east and you have states with hundreds of counties. So that means that our Chief Justice can meet with our 15 presiding judges and our 15 court administrators in those counties, and it's a smaller group. So to me, it's been easier to get things accomplished. The other thing is we're a right-to-work state, and this might sound strange, but sometimes it's difficult to do innovation when you have to negotiate with 20 different unions. And some of our court systems have union structures that are a challenge to get changes done. But we have been an innovative culture for decades, and so this is just a natural part. Now to spread it, the state courts are divided into regions, and the regions meet. They usually do a conference once a year. The Western Conference is going to be around Labor Day this year, and it's going to take up this subject, the delivery of legal services. And what I've observed over the years is what happens at their conference, the subject matter tends to spread to the East. And so it happened with bail reform and mental health reform and so forth. So that's one thing I think see coming is that maybe the other regions will take this topic up and it'll spread.
Yeah, so it's an observable phenomenon, but I don't understand the causation versus the correlation, right? I think that Dave undersells his importance, for example, I mean, in driving reform in Arizona and how he's been there. And so, the Western Conference is, I mean, lots of geographic area, but a small number of states. And it doesn't take a lot of leaders like Dave Byers to move the conference. But he's right that the Western Conference, for whatever reason, has been more willing to be innovative. And I'd like to hear from Becky about this, because part of me wonders if this has to do with just kind of the tradition when Utah, Arizona, others became states, and if our governance models, the empowerment to the Supreme Courts, whether maybe a lower number of judiciaries that are elected versus appointed, whether that might be part of the explanation. And Becky, I don't know if this is something that you've thought about, studied, but it's not something we've ever talked about.
Well, certainly there's a kind of a political science story to be told about whether there's just a few actors who can, I mean, you could have great leaders, but if they don't have the capacity to push because of the way they're institutionalized, then they're inspiring, but maybe not as effective. And so in both Arizona and Utah, you have really great leadership that is able to do things that may be harder in other places. I mean, think about New York State, where UPL is in legislation. So the Supreme Court cannot like it all at once, but it has to convince the legislature to change those rules. I would say something else about Arizona and Utah. They're relatively small. So to Dave's example, Justice Simonis, I can't remember, do you have 8,000 lawyers or 13,000 lawyers?
It's someplace in between there.
So you could talk, you could talk to a lot of them and have, develop a kind of a collective belief about it. And those are both contexts where deregulation and limited government are things that have been around for a long time that are valued broadly across those states. Now, if you think about the next context where this is in consideration, it's California. So California is very, very different. California loves regulation. It's got regulation about everything, right? And so maybe Jim wants to speak to this. The conversations that the California group is having about how to do a sandbox are somewhat different than you would have in a context where limited government is your goal. But let's think about also how much harder it is to do in California, which has almost 60 million people and I don't know, probably 30 million lawyers, right? So getting all of those people on board to go along with the change is just at scale a more challenging thing to do.
Go ahead, Bridget.
Great, thank you so much. And I will say that I realized I neglected to read the CLE password at the beginning of my Q&A, so I'm going to do that briefly right now. The CLE password, if you missed it in the poll, is TRAIN. That's TRAIN, something I haven't been on since March of 2020. My next question builds a little bit on some of what's going on in the Q&A, and thank you so much for these Q&A discussions, and talks about, I was hoping you guys could talk about kind of how you see the future of the one-on-one legal services model. And you've talked about ways that it could expand to non-JD, non-barred professionals, but how do you think, we might see the one-on-one legal services model change, if at all, and what role does technology and, the advent of new technology, what role does that have to play in kind of reimagining what this is going to look like in the future?
Becky, I think that's a you question.
We're all waiting each other out.
Yeah.
I mean, technology can automate a lot of things, right? So you can do your taxes and TurboTax, etc. It can make remote access to the automated thing a lot easier. But I've done some research in both rural and urban contexts with technological solutions that are consumer facing. And very often you need a human being to mediate between the person and that technology and the solution. And so those human beings are going to be necessary there for a really long time. Hopefully the technology will make them more efficient, more consistent, more accurate, but it certainly won't make them go away.
Yeah, I can add to that, Becky. I do my own taxes on using TurboTax. And I noticed this year when I was doing them, I had a question, and I could click a button for help, and up pops a lady who says, "Hello, I'm Mildred. I'm a 20-year CPA tax person. What's your question?" And you get some of that free, and if you have a more complicated matter, you can pay a modest fee, and they'll research it and give you the answer. I think that we'll see that in Arizona. We're going to see the companies like LegalZoom and others that are out there provide those services, um, add actually to their services by hiring Arizona attorneys to be part of their offering. And so the people who are filling out forms can also get legal advice, or actually they can intervene. I had an example with them where they can observe what you're doing, and there was somebody trying to I don't know. They were going to uh, copyright the name of their firm, and what they realized is they don't really need to copyright; they need to trademark it. Well, right now they can't provide legal advice, so they can't go in and say you're screwing this up, you're using the wrong forms. But if they become an ABS and they add lawyers, they could do that. So I think we're going to see that kind of combination at the consumer retail level.
Yeah, from my perspective, um, I mean, technology is going to play a huge role, and it's going to be a bigger and bigger role for sure. But we're also going to see an increase, a real increase in bespoke legal services, but being offered by non-lawyers. And to me, I mean, my own, my own judgment, and happy to be disagreed with by my colleagues on this, is that getting the community first responders, empowering them to provide legal advice, following the English model, is going to make the singular biggest difference in cracking the access to justice gap. I'm going to hijack this question for 1 second, because I want to push back on something that both Professor Sandifer and Dave said, and maybe somebody can tell me why I'm wrong about this. I don't see this as a question about whether the state is unionized or non-unionized, or even as lightening the regulatory load. To the opposite, those people that are coming into the sandbox are, yes, they can experiment and have offer a different service, but it's not light. I mean, it's regulation reimagined, not regulation removed. It is onerous, monthly reporting, potentially spot checks. I mean, all types of different things. If just, we license a lawyer and we set them free, and then, absent a bar complaint or something, they're free to offer whatever they want forever. That, when we're talking about entity regulation, that is a very, very different model with some real strict oversight. So I want to push back against this notion that this is the loosening of regulation, because to me, it's not at all about the loosening of regulation. It's just thinking about it in a different way. And rather than prescriptively saying, this is what's okay and this is what's not okay, is to make a data-based decision about what helps the public and what doesn't help the public.
So as one of the people who has to do that laborious work of contributing to that database decision, I think everything that Dino has said is absolutely right. The way I might contextualize it would be like this. You can think of the sandbox as an experiment in letting people do crazy things and monitoring them so that if their crazy stuff is too crazy, you can stop them. And it is that. But it's also an experiment in saying, we had all these rules and we have no evidence-based reason for thinking that these rules are useful. So let's relax them and see what happens. And so it's a test of the rules themselves, not just the weird models that people might come up with. So we can imagine a future Utah where this experiment runs for long enough that Utah says, you're right, those were dumb rules. We're going to release those rules for some whole set of activity, but you have to be willing, your word is reimagine. We could say deregulate. You have to be willing to entertain that idea in order to go down that path. But you're right, there's nothing, it's very hands-on. It's a very hands-on way of monitoring legal services. And it's much more hands-on than we are with lawyers who, as you say, we license them and then we let them go in the wild.
Great. Thank you so much. With that, I think we are out of time, but there seems to be, I have so many more questions I could ask you, and seems to be lots to discuss in the post discussion. So as a reminder, that information's in the chat, and I believe it'll be emailed out to all participants as well. So we hope you'll join us there. And now I'm going to turn it over to Jennifer Leonard, and she is Penn Law's Chief Innovation Officer, and she's the Executive Director of the Future of Profession Initiative, and she's going to take it from here.
Thank you so much, Bridget, and thanks to our audience members for your great questions. And we are enormously grateful to Jim for bringing conversations like this to our community in his new role with us at the Future of the Profession Initiative. And of course, we're grateful to our panelists for their leadership on these issues and for sharing their valuable time and expertise. We hope all of you will come back for more discussions and to work and be involved in some of the work that Jim and FPI are doing in this area. I'd also like to thank Naoshi Giles from our conferences and events team, Dalila Lewis from FPI, and our partners in ITS for bringing this conversation to life. We hope you'll help us improve our programming by sharing your feedback in the survey linked in the chat. Our next webinar in the Reimagining the Future of the Legal Profession series will take place next Wednesday, also from 3 to 4:15 Eastern Standard Time. During that session, we'll explore the future of lawyer formation, a conversation that will be led by our dean, and we'll feature today's moderator as an expert panelist. Jim will join us to discuss his focus on teaching leadership to lawyers. You can learn more and register at futureofthelegalprofession.org. And now we're going to take a quick break, but we hope that many of you will join us to continue exploring these topics. We have lots of great questions remaining in the chat, and others I'm sure audience members have. So starting at 4:30 Eastern Standard Time, we'll convene to have an informal, unrecorded discussion of these issues. You can find a link to that Zoom session in our chat. You should also receive an email from Penn Law's conferences and events team momentarily, which contains the same link. And we ask for your patience and thank you in advance for your patience because the link will probably arrive in your inbox around 4:25, so keep an eye out for that. For those who aren't able to join us, we thank you for your attendance today, and we look forward to seeing you at other programs in the future.